The 10:30 a.m. docket for Tuesday, October 25th, 2022 consists of one case. Appeal number 124718 in the matter of Shayla C. Johnston, original action and attorney discipline, no briefs filed.
May it please the court, Amanda Voth on behalf of the Office of the Disciplinary Administrator. And with me at council table will be seated Kathleen Lippert, present and ready for argument. And Madam Chief Justice, I would request 5 minutes of rebuttal time, please.
5 minutes granted. Thank you.
Shayla Johnston, present and pro se, prepared for argument.
Thank you, counsel. Approach. I'm sorry, Mr. Shima. Cut Mr. Shima off, but thank you, Mr. Shima. You may come forward, please. Thank you. Both whenever you are ready.
May it please the court, Amanda Voth on behalf of the Office of the Disciplinary Administrator, and seated with me at council table is Kathleen Lippert. This is an original action in attorney discipline regarding the respondent, Shayla Johnston. This case is before this court on a final hearing report that was issued following a 5-day formal hearing. In the 139-page formal hearing report, the hearing panel found that the respondent violated 17 rules of professional conduct, most of them multiple times. The panel recommended disbarment as the appropriate sanction. The evidence presented at the hearing showed an extensive pattern of serious misconduct. Highly summarized, the respondent engaged in a course of conduct of abusing the legal process by filing meritless motions and creating distracting sideshows to delay and obstruct cases. She engaged in deceptive conduct that misrepresented the facts, and she attempted to dictate, harass, and intimidate the attorneys, court, and non-parties into complying with her agenda. When that was not successful, she made unsupported and false accusations of fraud, collusion, and crimes against opposing counsel, the court, and others. This case is before this court on admitted findings of fact and conclusions of law. Although the respondent did file generalized exceptions to all findings of fact and conclusions of law, she failed to file a brief even after this court on its own motion gave the respondent a second deadline of June 14, 2022. That order also allowed the respondent to seek an extension, but the respondent did neither. As a result, the court issued an order declaring the findings of fact and conclusions of law were deemed admitted under Rule 228. Because the findings of fact and conclusions of law are uncontested, I would like to focus my argument on sanctions. At the formal hearing, the ODA recommended disbarment. The respondent recommended dismissal. Based on the conduct that was presented at the hearing panel, as well as the conduct the respondent has continued to exhibit, the ODA continues to recommend disbarment. In determining the appropriate sanction, the court looks to the ABA standards for guidance. A lawyer's mental state is one of the key factors that governs the severity of the presumptive discipline. The ABA standards define intent as a conscious objective or purpose to accomplish a particular result. It's the highest level of culpability. The hearing panel found that the respondent's misconduct showed repeated intentional and knowing acts, and that the presumption was disbarment. Because there's so much misconduct that could be discussed, I want to touch on just a few examples to show the reason that disbarment is appropriate. First, the respondent abused the legal process by using it to delay or obstruct litigation. She also made meritless claims and contentions unsupported by facts and that contained false statements and misrepresentations. For example, in the KE case, the respondent represented a father in one domestic case, which improperly blossomed into 3 cases, resulting in adverse findings and sanctions against the respondent. One of the mothers gave notice of her intent to move per statute. Instead of the respondent filing an objection or motion to modify, she instead filed a petition for abduction prevention measures under a new case number, falsely asserting that the mother was going to abduct the children. The respondent was then able to obtain an ex parte order, which she used to allow her client to wrongfully refuse to return the children to their mother. Then, on the eve of the hearing, on the mother's motion to enforce the parenting plan and for sanctions, the respondent filed adoption petitions, which by statute preempted the domestic and abduction cases, and they were assigned to a different judge in a different division. Later, both the court that heard the abduction cases, as well as the court that heard the adoption cases, sanctioned the respondent. One court found the abduction cases contained unfounded allegations, the evidence of abduction was unsubstantiated, and the pleadings were for an improper purpose. The other court found that the adoption petitions were filed solely to cause delay, that they were not warranted, and the respondent's arguments were frivolous and lacked merit. As another example, in the RT case, as Judge Rundle found, the respondent used an unjustified scorched earth approach on a simple motion to modify child support. The court found that she made unsubstantiated allegations of unjust enrichment, among others, and ordered the respondent to report herself to the Office of the Disciplinary Administrator. The final example is that in the KV case, although an ex parte temporary custody order was issued and the respondent knew about it, the respondent refused to assist in compliance with the order and instead filed motions seeking to vacate the order and to dismiss the case. In those filings, the respondent argued that the ex parte orders were being used by DCF to kidnap children considered marketable for state profit and requested the court voluntarily cease the practice to prevent further escalation of the rumored racketeering. The court found the motion meritless and that the mother was attempting to circumvent the process and avoid the sink case. The second type of misconduct that I want to mention today is that the respondent abused the legal process for the purpose of obtaining evidence through improper methods. For an example, in her representation of NW and ZW, the respondent used a business record subpoena on behalf of her clients in a case to which there were not even parties to obtain a deceased child's medical records after the court in a sink case denied respondents' efforts to obtain those same records. The third type of misconduct is that the respondent abused the legal process by repeatedly refusing to comply with court orders. One example is that in the KE case that was just mentioned, the respondent's conduct and counseling resulted in the mother of the children, who had primary residential custody, to be without her children for 23 days. Another example is that in the NV case, the respondent refused to comply with a temporary custody order and had to be ordered to either have her client produce the child while the court waited or have law enforcement pick up the child. After consultation, the respondent told the court that law enforcement had to get her child.
Can
Another,
I ask you a question on the ZW NW case? That
Certainly.
was the sink case. I thought statutorily the grandparents had standing by statute. Maybe I'm missing the factual progression of that case
Sure.
somewhere.
so the respondent went into a different case, into a domestic case, to obtain the records that the sink case, she was not allowed to get them in.
And issued the subpoenas under 245A or whatever
correct.
to get those as business records.
That's correct.
Okay.
She did file a motion to intervene in that case and it wasn't ever granted, and she went ahead and filed the business record subpoena anyway. Another example is that in her own case, where she refused to comply with a court order for unsupervised visitation twice, asserting that the court had no authority to require her to do something that she believed was not in her child's best interest. The court found her in contempt. The fourth group of misconduct I would like to talk about is that the respondent exhibited extensive patterns throughout the litigation of many of the cases of attempting to intimidate and influence judges in their decision-making through unfounded accusations of racketeering, collusion, criminal obstruction, retaliation, threats to pursue federal relief, and to file complaints against them. The respondent used these intimidation tactics in her own case with RT, KV, and also in the KE case. Fifth, the respondent exhibited similar bullying and intimidation tactics to opposing counsel and to third parties. In her own case, she sent an email to the judge and opposing counsel, calling them criminals and threatening interstate stalking orders. In the DF case, she contacted the child's therapist in a domestic case to which she represented the mother, and without her client's authority, discontinued the therapist's services. The mother had to file a pro se motion the next day stating that the respondent, her own attorney, it was a misrepresentation. The respondent's communication was a misrepresentation. Of note, the respondent's misconduct continued in multiple cases over several years, despite admonitions, sanctions, a contempt finding, and disciplinary complaints. And finally, the respondent's conduct has not stopped. The hearing panel found that the respondent continued her abusive litigation practice during the disciplinary proceedings. And after the final hearing report, the respondent continued to engage in the same patterns of conduct. For example, she has continued her practice of not following court orders and procedure by failing to file a brief and instead filing other documents not appropriate for this stage in the proceedings, including last week's untimely and improper notice of additional authority. In addition to the intent, the respondent's conduct has resulted in injury, prejudice to the administration of justice, damage to her clients in both the outcome of cases and in the sanctions imposed, injury to opposing parties, and harm to children by disallowing parenting time. In applying the ABA framework, we think that it's clear that disbarment is the appropriate sanction. And we would ask this court to adopt the hearing panel's findings of fact and conclusions of law. And we would recommend that this court disbar the respondent.
Counsel, I have one quick question.
Sure.
And it concerns some of those late filings that you referenced.
Yes.
And it's a little bit difficult for me to make out exactly what's being argued in those filings. And I recognize that they're procedurally out of bounds, et cetera. But I think if I construe as I understand it, and of course, the respondent can address this as well. The argument goes something like there are laws and rules in place that prevent me from bringing forth the evidence that would corroborate these claims that I've made. And that because of that, it's either, and that, well, let's just leave it at that there are statutes and rules that prevent the respondent from bringing forward with the evidence that she claims would support the allegations made. I just wanted to hear your office's response to that.
Sure. So it seems like the respondent's reasons for not testifying or putting forth evidence is a moving target, kind of depending on what the rulings are. I know that she at one point claimed that under 1.6, she would not be able to testify or put on evidence. However, it was pointed out to her in the hearing or one of the pretrial conferences that 1.6B does allow her to defend herself in an action. She also has mentioned that consent, she needed to get her client's consent. That's also not required to defend herself in a disciplinary action. I think another reason that she provided was privilege. And she did not, the party asserting the privilege bears the burden, and she didn't ever assert the privilege or provide any facts. So it's our office's position that none of the reasons that she provides are sufficient to deem it so that she is unable to provide a defense.
Did your office ever in any of these proceedings, or frankly, did any government agency or court below ever tell the respondent she was not permitted to bring forward certain evidence because of some rule or statute?
Not that I'm aware of. In fact, it was pointed out that for the sync cases, which there are only 2 sync cases out of all the cases we're talking about, for the sync cases, the Office of the Disciplinary Administrator did get orders from the district court to access those records to be able to use them in the disciplinary proceedings. The respondent would have been welcome to use those records as well, or she could have gotten her own court order, which she did acknowledge in the November 17, 2020 hearing.
I am Shayla Johnston. I am, in addition to being an attorney, licensed by this court for 22 years. I'm a compliance and ethics expert. I am a college and graduate school professor with 10 years experience teaching in academia. My first journalistic award was gained at age 16, which was a mighty long time ago. I am here as a result of my most recent success implementing social reforms to cure an epidemic of child abuse deaths in Kansas in the wake of my blood relative's murder. Right now, I am a suspended attorney in full compliance with this court's rules, all orders of all district courts, my whistleblower bankruptcy directives in Colorado, and all of the consent forms signed by my former clients. I am owed considerable amounts of money as independent legal counsel who provided successful family preservation services for families at risk of foster care placement over the last 4 years. The Family First statute that provides for payment of independent legal counsel fees went into effect December 2018. And the cases that I won and I took that were child abuse cases have all come due and owing around the time of the motion to temporarily suspend me. So it's important before we go further for me to emphasize that this is an attorney disqualification case when there are no ripe issues of attorney disqualification pending in this court. There are no complainants who are victims in this case. The complainants are DCF contractors and county agents who are mad that I took over their monopoly of business, and I did it well. To date, even during suspension, I have won about 90% of my cases in absentia, even with pro se's. Today in the courtroom, I know what I asked that no one asked me to identify her, is one of the so-called victims that the state says I harmed. She contests those factual findings, and no one at the disciplinary administrator's office ever called her, interviewed her, asked for her permission to publish her child's social security number, date of birth, and medical records from a sync case. She is here today. She wants you to lift the temporary suspension that you've put on me without due process or any probable cause, so I can attend with her to go make criminal complaints on the prosecutors who have abused the good name of this court in the interest of collateral contractors who want to maintain a monopoly over the business that I have properly introduced good competition in. That is what this case is about. And there is no precedent in this great court to give standing, to give subject matter jurisdiction, and certainly no precedent in this court to procedurally take advantage of a DCF gag order in order to get a default judgment that denies my rights under natural law. Justice Segal, and I hope I'm pronouncing it correct. You correctly identified the preeminent legal issue in my world, maybe not in yours. DCF gag orders were statutorily implemented through 38-2109B and remain in place today, even though they are now presumptively unconstitutional, pursuant to 10th Circuit's recent decision, Peck v. McCann. thank you for giving me the grace of recognizing that not only am I gagged from presenting substantive defense, all of my witnesses are gagged. And furthermore, I'm under active threat of jail. I've been threatened with jail in Sedgwick County courts or to be taken into medical testing or what have you, whatever can be come up with in both Sedgwick County and Cali County. My only saving grace is that law enforcement refuses to implement the orders, as they rightly should, because they're unconstitutional. So technically, well, I shouldn't say technically, presumptively, I should be able to discuss these things with you today. However, I have entered into now for 2 years, 6 different efforts to remedy and disavow that enforcement of gag orders with the disciplinary administrator, through panel proceedings in the district courts with independent judges, and all of the 170 cases I was forced to withdraw from without a single complaint. I am under those orders and they refuse to disavow them today.
Did I understand your argument correctly that from your perspective, those orders, as you call them, prevent you from bringing forward evidence that you believe would corroborate certain claims that you've made?
Yes, but furthermore, they also gag everybody who was present and qualified witnesses.
And some of the rule violations go to alleged claims that are not based in fact or lack merit. And so I understand the relevance of the argument you're making with respect to those findings of rule violations. There are other rule violations found, things like failing to comply with court orders and so on. Do you think that the gag order issue, is that relevant to those as well, or only to the rule violations that talk about meritless claims?
In the realm of interpretation of these DCF gag orders, which exist in 48 states, I guess 47 now that Colorado has, dismantled theirs. There are differing ways that those are interpreted. In Kansas, they are interpreted, in my practice, they're interpreted that when there is information contained in a DCF record about a child that was allegedly a child in need care, in other words, there was a DCF report, everything that's in that record contained by DCF, everything is subject to gag order. That means you can't paraphrase it. You cannot include documents. You cannot redact it. And furthermore, you can't even show your clients. So I still today have taken extraordinary measures to open up a new corporation and use my journalistic privilege to maintain those records because I know it's my fiduciary duty. But today, the state has put into your possession about 10,000 pages of documents under seal that are non-compliant with federal CAPTA laws because they weren't redacted as Chief Justice Lukert signed into the new version of 7.043. And they are required to be redacted. So to answer your question, if there are allegations of me violating a court rule, I would say my first argument to that is not a ripe issue, and issuing an advisory opinion without me being able to tell you how those were actually resolved is kind of putting the cart before the horse in a very dangerous way for this court. You're being asked, so I'm sorry if I don't mean to evade your question. I have to evade it. But like I've said, with me today in court are crime victims who have been gagged and silenced. More than one of them who are with me today have gone to jail. It's a real threat and it's absurd. But no one can say that I violated court orders if I stand before you today after being suspended for 9 months and I didn't go to jail. Furthermore, if you've heard from no one, none of the attorneys, nor the judges who were actually present in those proceedings, and you haven't, there were no contemporaneous reports filed. The only complaints that have ever been filed against me in 22 years were people I made a record of error, crime, or fraud appropriately, as is my required duty. These were defensive. So, yeah.
I think, well, I don't think I know that this court would take those kinds of allegations, which are very serious ones, quite seriously, and would hope to evaluate them fully. One of the hurdles that we face is that as part of our procedures, we do provide a full opportunity for litigants to present all the arguments in briefs. And so we face a hurdle here of not having briefs in this case. So I would wonder, I just wanted to ask you to address that, the fact that you were given that opportunity, but didn't avail yourself of it.
Thank you. You know, I had all of these arguments all written out to argue subject matter jurisdiction and such, so I'd much rather have a hot court to respond to. Justice, I can't in candor convey or acquiesce to you all taking appellate jurisdiction over cases that you have rendered appellate decisions in declining jurisdiction. I have a problem with that. I don't have a problem with making motions to dismiss or involuntary dismissal based upon lack of subject matter jurisdiction. But I can tell you that all of my complainants and witnesses fully participated in investigations when they were protected by Rule 212. And ODA has proof that we fully complied, and the majority of those situations resulted in no probable cause findings. So what is in front of you today are two cases that were no probable cause and my own custody case for which there is no complaint, you understand? No complaint. And you all specifically declined to hear. It was brief. This. October of 2015, declined to hear by the Kansas Supreme Court. So it was briefed.
I was thinking of the briefing in this particular case. Again, I'm actually trying to give you the benefit of the doubt and fully understand your argument. It sounded like you said you didn't file briefings in this case because you questioned subject matter jurisdiction. Is that a fair?
It puts,
summary?
I'm sorry, it puts me in a very precarious situation. Number one, these cases or the allegations that you have in front of you are most easily and carefully disposed of by a motion to dismiss because there's no subject matter jurisdiction. It is the best way that I can protect you all, as you have to have subject matter jurisdiction. You understand that you've been put in a position right now where there's a lack of immunity. And the only person standing on this side of the room over here who has statutorily protected immunity is me. Doing to 382109C. I would love to give you a brief. I would love to give you a 300-page brief is what it would take. But these are all unpublished cases. I can't publish them without violating Hague Treaty, without violating UCCJEA. And they're on accusations that requesting you all to make an advisory opinion in many cases where these are interstate issues. I'm not going to do that to you, even if I have to go and be disbarred. I will not do that. What I intended to present to you, but I'm happy to entertain more questions, is I am honored to be here today and to use my good surname, you all, to reconcile what I think is probably a refinement of the First Amendment attorney cases that you all have heard, which I don't have enough time to really expound upon, although I'd love to. After Peck. Peck makes it very clear that private attorneys, ones not employed by the government or contracting with the government, are the whistleblowers of this profession. I think you all have overextended the Gietta Pinkering rule to into an unconstitutional realm that has, according to the 10th Circuit, resulted in disastrous consequences. But what I want to convey to you today is I want you all to exercise your constitutional full authority to interpret your own rules, to dismiss my case, to vacate the orders of temporary suspension, which did not conform with temporary injunction rules in what frames soever, and to do that expedited so I can get back to court because these cases are flailing. And I am the expert who handles them, and I handle them well. If there was something to dispute here, you would know about it. There would be evidence of jurisdiction or complaints in the 10,000 pages of documents. There is none because no one complained about me. 5 days of testimony, I gave them an extra day. No one testified. That's why there are no citations to testimony. You can vacate it on subject matter jurisdiction, which you kind of have to because that means everything's void. According to your rules, which we don't have enough time for me to go over, but I certainly have all the cases cited. I would love to brief, but I need a ruling on subject matter jurisdiction before I do that because there are immense problems maintaining your all 7 of you in your seats. Essential to the stability of this court and the changes we need to make together to remedy this problem of you all seeming to have taken actions that violate Kansas federal contractor status. They can be fixed. I need to be able to be actively licensed to do that, and I'm happy to put my name on something that will preserve the independence of this court and the independence of private legal counsel.
There are just a couple of points I want to quickly address, and then I'll waive the remainder of my time. The first one is jurisdiction. This court just last week in the Jordan case found that this court does have jurisdiction. It said that the power to regulate the bar, including the power to discipline its members, rests inherently and exclusively with this court. I would also cite to Rule 202B and Rule 8.5. The other issue, the respondent had mentioned the Peck case. I just wanted to point out that that wasn't ever raised to the hearing panel. It wasn't raised in any exception, and then it also wasn't briefed, so that's not properly before this court. If this court doesn't have any other further questions, then I would waive the remainder of my time.
Questions? Thank you.
I'm looking at the hearing panel order and this didn't jump out at me until.
Okay.
So, format of this hearing panel report seems different because it doesn't reference complaint numbers, facts that go under that. And you're apparently prepared for this question, but what's going on?
So the reason is different is because there are a couple of reasons. So there are 4 DA case numbers. One of those DA case numbers has 2 district court cases that go underneath it, or like situations, I should say. So one is the HD case under one DA number, and under that same DA number is the KV case. And so there are multiple cases under the same DA number. Additionally, the respondent's own case didn't have a DA number assigned to it. And so that is the reason that it is set out in the format that it is.
Where did the complaint come from? I mean, typically these things set out that you get a complaint at a certain date and here's where they, some lawyer got mad at the other lawyer and filed a complaint, or some judge got upset, or a client, got upset.
Are you referring to the respondent's own domestic case?
I'm just talking about the disciplinary action that's being brought here under different complaints, where'd the complaints come from?
There are multiple different sources. In one of them, the judge issued an order telling her that she needed to self-report. In two of them, it was a deputy district attorney. In one of them, it was a judge. In one of them, it was opposing counsel.
You're saying those individuals actually contacted your office?
Right, those are actually complaints that we received. As far as her own domestic case, what happened there was that in the RT case, which is one of the cases that was complained about that we received a complaint on, one of the documents that the respondent had filed referenced all of this racketeering allegations, and it specifically cited to her case, her own domestic case. And so that's why the person that was reviewing it, wanted to see what are these allegations of racketeering, and followed up on that. And so the respondent referenced her own domestic case. And so then the deputy disciplinary administrator then looked at that case. And so that's how that came to light, is from the respondent's own motion.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement.